You might think RMDs would be as easy as ABC, but we can only wish it were that way. Those required minimum distributions become even more problematic when they involve an inherited retirement account. I'm Patrice Sikora with Foster & Motley's Nick Roth. And Nick, legislation passed by Congress in the past few years has changed the rules for retirement plans. Tell me about that.
Happy to, Patrice. Thanks for having me back. The retirement plan rules changed dramatically under two new laws that were passed in the last 5 years. The Secure Act was passed in December of 2019, and Secure 2.0 was passed in December of 2022. Secure is abbreviation for setting every community up for retirement enhancement, and it changed the landscape of how people manage their retirement accounts, think 401ks and IRAs, going forward. So this podcast is actually a follow-up on two previous episodes that we've done, a chat about required minimum distributions back in March of 2022, and what does the Secure 2.0 Act mean for me from March of 2023. The main topic of today's conversation will be surrounding what could be a difficult period in someone's life, and that's inherited IRAs. By their very nature, this means that someone in your life, likely someone close to you, has passed away, and that can come with its own grief and emotions. And now, with an inherited IRA, you also have some financial complexity, and introducing money into anything can make things even more emotional. Not to mention that this is likely something that needs to be revisited each year, which can bring back a wide array of feelings depending on everyone's individual circumstance.
Yeah, I can believe that. You're continually reliving the passing of a relative you may have cared for very deeply. In fact, they cared for you enough to leave you their account. So talk about these rule changes.
Today, we're going to be discussing the final IRS updates to the rules surrounding inherited IRAs specifically, and specifically where the last owner passed after the year 2020, which makes them subject to these updated rules.
Now, wait a minute, you said final rules. Final. How final are these final rules, and what happened just before them?
Yeah, that's why we're updating these last two episodes that we recorded, Patrice, because it's important to take a step back and understand how government passes tax laws. Whenever Congress passes new rules relating to tax law, there's a period of time where the public has to make their best educated interpretations of the rules. And eventually, the IRS comes and weighs in and provides guidance on their interpretation of the rules. And it gives us more specific directions on how they expect taxpayers to behave. So at the time, these changes were passed for inherited IRAs. Our at Foster & Motley and seemingly everyone else's interpretations were that these rules were going to make things very simple. The reason for our conversation today is that the IRS has officially weighed in, and starting January 1st, 2025, things are not so simple.
Congress simple, IRS simple. No, they just don't go together, Nick. You know that as well as I do. So what about all the people, though, who made decisions in good faith based on what they thought was going to happen?
Luckily for us, Patrice, the IRS has already taken the step to confirm that anyone who used their own interpretation of these laws between 2020 and 2024, before these final interpretations were released by the IRS, won't be subject to any penalties. This is a nice silver lining in the middle of the complication, so people don't have to worry about going back and correcting any action they took the past several years, like you said, in good faith.
But I guess that's good news. But as we go into the inherited IRAs, what terms or concepts do people need to know so we have a better understanding of the conversation as we go forward?
Yeah, let's start out by tackling the two main types of retirement distribution rules that we're going to discuss today. The first is a 10-year rule, and we've talked about this in the past, but this states that once you inherit an IRA, you have 10 calendar years to distribute the account in its entirety. So, for example, if I had a parent pass away last year in 2024, and they left me an inherited IRA account, then by the end of 2034, that account would have to be empty, or I would be subject to some kind of penalty. Whether I distribute everything in the first year, this year, 2025, or if I waited until the year 2034, that's up to me. That is the standard 10-year rule as it's been defined under the new rules. In addition to that, we have what a lot of people would refer to as the old rules or stretch distributions, which state that some beneficiaries will be required to take a small amount out of their inherited IRA annually. And we'll discuss who is required to take those stretch distributions a little bit later. But the real complicating part of the new rules is that some individuals are going to be subject to both of these distribution rules. They'll be required to distribute an account within 10 years and distribute a little bit along the way via stretch distributions.
All right, Nick, is there an age or date that determines when the original owner had to start taking distributions? And does that come into play here?
It does, Patrice. And that date is called the required beginning date. And the date that the original owner had to take distributions could have been their age 72, 73, or potentially in the near future, age 75. So it's important to understand at what point the person you're inheriting the account from passed away in their own IRA distribution journey. And that's called the required beginning date, which will come up again in a moment when we talk about the rules.
So, how do people know which category and the sets of rules they have to follow?
Everyone is going to fall into a beneficiary category. And we're going to focus on two today, and that's eligible designated beneficiaries and non-eligible designated beneficiaries. Just off the top, most people are going to be non-eligible designated beneficiaries. There is a very small subset of people that will be considered eligible designated beneficiaries, and those are surviving spouses, disabled individuals, chronically ill, people who are less than 10 years younger than the person they inherited the account from. So, for example, maybe a sibling passed away and you're less than 10 years older than them, you would qualify actually as an eligible designated beneficiary. And lastly, it's minor children. And luckily for us, the IRS has stated that anyone younger than 21 would be considered a minor children, and you don't have to worry about your state's rules about when an individual reaches the age of majority. Anyone under 21 would be considered a minor child for these purposes.
Any other types of beneficiaries we should be concerned about?
There is another type of beneficiary called a non-designated beneficiary, but these are generally charities, estates, and trusts, which can get even more complicated. So we aren't going to dive into those today. But with that being said, if you have a situation where you have inherited a trust that owns a retirement account, I'd highly encourage you to engage a financial professional to help you understand those complicated rules.
Okay, back to the revamped rules. Go for it.
Before we get into the specifics, the simplest way to explain the IRS's updated interpretations is that in most cases, if the person you inherited the account from was required to take an annual distribution from the account that you inherited, you almost certainly have to take annual or stretch distributions as well. Conversely, if the person you inherited the account from did not have this annual requirement when they passed, for example, they passed before reaching their required beginning date that we discussed earlier, then you likely don't have to either. In this case, you'll likely only be subject to the 10-year rule. The 10-year rule is fairly straightforward, but our listeners can go back to the March 2022 podcast to learn about the specifics.
And there was something in that podcast that we all pretty much thought was going to happen, but did not. So talk about that, please.
That's right, Patrice. At the time, based on all the interpretations that we were seeing, we thought it was fairly clear that everyone was going to be subject to a 10-year rule. And so we stated that on the podcast. As we've possibly alluded to already, that isn't necessarily the case. So we just wanted to correct the record. Anyone who inherits an account and is an eligible designated beneficiary, as we defined them earlier, could have the option to not be subject to this 10-year rule. With that being said, I think it's important to point out this will probably be an exceedingly small group of individuals and not apply to most people, but it is possible.
All right. Appreciate that update. And I must say, this just reflects the fact that at Foster and Motley, you pride yourselves on being up to date and paying attention to the details. So let's turn to the seemingly complicated situation where an individual might be subject to both the 10-year and the stretch rules.
And that's right, Patrice. Most people who inherit an IRA will be subject to both the 10-year rule and stretch distributions. So, what does that look like? Most people will be adults when they inherit an IRA, and usually they inherit the account from an elderly parent. This means that they will likely not qualify for any of the special carve outs that we referred to before and would be considered a non eligible designated beneficiary. Assuming the person who passed away lived a long and happy life, they would have reached their RBD prior to their death. And given that information, the person who inherits this account would be subject to both of these requirements that we've been talking about. They'd be required, at a minimum, to take small distributions from the account annually in years 1 through 9, and ensure that the account is emptied within the 10-year period following that individual's passing.
Are there any pitfalls an individual could run into when doing this?
The important thing to keep in mind with this fact set is that people who are subject to the annual stretch distributions, those distributions almost certainly won't be large enough to deplete the account within the 10-year period by themselves. Therefore, at some point, to satisfy the 10-year rule as well, individuals are going to have to make electively larger distributions in order to satisfy that other rule as well.
Yeah, that does make sense, though. It does. So, obviously, these rules get complicated. What else should people know?
Patrice, I think the only other idea, without complicating things too much and having our listeners' heads spin, is the concept of inheriting an already inherited IRA, which comes with a whole different set of rules.
Okay, inheriting an already inherited IRA. We're going down a couple generations here?
Potentially a couple generations. I think the most common example of this actually is, let's say both of your parents have passed, so you've inherited an IRA from them, and then you have a sibling that unexpectedly passes. That sibling doesn't have any children, let's say, so they leave their now inherited IRA from your parents to you. That is now a inherited IRA, right? So, unfortunately, these rules are so complicated that the advice from one very well respected financial planner in the industry to other advisors was, don't waste your time memorizing it. Luckily, this doesn't happen very often, but I just wanted to put that out there in case anyone finds themselves in that situation, in which case I once again highly encourage seeking the advice of a financial professional.
And as you said, there won't be penalties looking back, but are there penalties for not complying going forward?
Obviously, Patrice, there are. But it's not often that the government reduces penalties, and in this instance, they have. Previously, the penalty for not properly completing an RMD was 50% of the total required distribution amount. Now, the penalty is 10 to 25% of the entire amount an individual is required to distribute. And the reason for the range there is the quicker you correct the distribution, the less the penalty will be from the IRS. So if you take a long time to correct it, then the penalty can be up to 25%. But if you correct it quickly, then the government issues some.
They give you a break.
Yeah, they give you a break.
What should people receiving an IRA think about doing first?
At the end of the day, people don't need to memorize these rules. The important thing to remember from our conversation today is that inherited IRA rules can be complex, and worse, that complexity can come during an emotional time. But there are resources available to help you when this time comes. And if you have a trusted financial professional, they should have all of the resources to help. If you don't and you're struggling through some of these complexities, we here at Foster & Motley would certainly be happy to help as well.
All right, and how can someone reach you at Foster & Motley?
The best way is our website, fosterandmotley.com.
As you have learned, there are many things to consider if you inherit an IRA. Rules can change, and you want someone who's up to date with the latest legislation and what it can mean for you. Well, the folks at Foster & Motley may be that someone. Be sure to follow this podcast to know when a new show is ready for you, and of course, please share it with others. Thanks for being with us.